All right, so one more time. Welcome to How to Patent Your Invention and any invention and get the right protection for your big ideas. This is, again, my first live stream, so please just drop your notes in the chat if something is wonky or whatever. Let me know, and we'll do our best to make our way through this with as few glitches as possible. Two really quick things before we dive in. Number one, I am not an attorney. This is not meant to be legal advice in any way, shape, or form. I'm going to teach you the basics that you need to know to make a good business decision for your innovations and the strategies that I personally use to protect absolutely all of my intellectual property. The second thing I want you to be aware of is be sure to stay online with us today until the very end of this to find out how you can get a free 1-hour consultation with me and to qualify for a completely free, comprehensive patent search done absolutely for you. And with that, let's dive in. A little bit about me, in case you have not been following or are not familiar with who I am. My name is Lisa Lloyd. I own and am the founder of Lloyd Marketing Group and the Invention Accelerator. And I've been inventing, patenting, and licensing products for almost 30 years. And I absolutely love helping people who are feeling maybe stuck and confused about what to do next and moving them into instead having the confidence and the competence to build a successful invention licensing business. I've been doing this, like I said, for about 30 years. I have 12 patents of my own, and my products have done a little over $30 million in retail sales. I've had incredible opportunities to be in numerous magazines, on television. I've been in lots of news programs, most notably Shark Tank, but Good Morning America. Even Dr. Phil interviewed me as a successful inventor. And as I mentioned before, it is my deep desire, my passion to help translate for you what the tips, tricks, hacks, and special processes are, best practices are that I use that have made me successful so that others can hopefully come up with more and even better ideas and be successful using some of the mistakes that I've made and learning from them. In today's talk, as you know, we're going to talk about Protect. Now, this is the big picture of my overall strategy for inventing and licensing. What you'll see here is a stage gate process. And what I do is built on the premise of taking very small but calculated steps at each stage to determine if you have a green light to keep moving forward and continue investing more of your time and money, or a yellow light maybe to hit the pause button or slow down just a little bit while you're kind of feeling something out, or maybe even a red light. It's time to stop, walk away, and move on to your next great idea. And today we're going to focus just on this stage right here, which is how to protect those ideas. So the first thing that you need to understand about intellectual property is that it refers to creations of the mind, right? So they're in here, but they're like real property. Once the United States Patent and Trademark Office says that you own it, you can do whatever you want with it, and no one else can make it, use it, or sell it without your express permission. So it's kind of like a house, right? If you own real estate, you can either rent a room in the house, you could rent it for a period of time or in perpetuity, or you can just outright sell it. In the same way, intellectual property is an asset that may even survive you, in fact, that you could will to your heirs. So that's intellectual property. And we'll talk about copyrights, trademarks, and patents, beginning with copyrights. So copyrights are intellectual property that protect your original works of authorship. So as long as you can see from the list here, that includes books, pictures, art, anything that you would sculpt, create, that sort of thing. Original works of authorship. You can assert your copyrights absolutely free the moment that you author it, just by adding the Circle C followed by the year and the name of the owner. So whether it's you personally or if you've got the copyright under a business. So the Circle C is totally free, followed by the year, and then the name of the author or the company that owns that copyright protection. As an inventor, you might use copyrights for content that you create, like for your website, if you're going to sell it. If you have any marketing materials like a sell sheet, for example, you may want to add copyright to. Even instructions for your product. I did this with the French Twister, my first product, when I licensed it, and they ended up using those instructions. I didn't get compensated for it, but I did put everybody on notice that I asserted those were my instructions. Protection for copyrights lasts for your entire life, plus an additional 70 years. So like I said earlier, it will survive you, and you can pass this on to your heirs. They last a little longer for companies. So if you do decide to get a copyright and you're staking your income, your ability to earn money off of it, then it may be in your best interest to put it inside of a company because it does last longer, but you should speak with an attorney about that to fully understand and weigh the cost and the benefits. In general, adding the mark is completely voluntary, just like the copyright. It's totally free, and you can add it at any time. However, if you choose to register it with the USPTO, then you'll just pay a small fee of $45 to $65. Now, you can license or even sell your copyrights without ever registering it with the USPTO because it is yours intrinsically. You created it. But if it's your intention to license or sell it, it's probably in your best interest to go ahead and register for a number of reasons. Most people choose to register because they want to have all of the facts about their copyrights on public record with the USPTO and to receive that certification of registration. You can't sue someone in federal court without it being registered also. So if you're concerned with someone copying you, just putting that Circle C and asserting those rights, putting the world on notice that that's your original work of art or authorship, then and somebody knocks it off. If you want to defend those rights or enforce those rights in court, you will need to file a registration. And one last quick tip on copyrights. If you have invented something that maybe can't be patented, but it's made with something like a pattern, for example, maybe it's a bedspread that has a new way of connecting to your bed, or sheets, or it could be apparel or accessories, anything like that. If there's a pattern, then you could actually copyright the pattern in addition to or instead of paying for a patent. Trademarks are a little bit more complicated, and feel free to drop in your questions as you have them here. I'll be checking back regularly and jumping in. I know that there's a delay, so forgive me if it takes me a moment to catch up with your questions. Trademarks are a little bit more complicated. They're used for a symbol, word, or words in combination representing a company or a product. So it could be any of these that you see here on this list, like the name of an invention or a logo for your business. You may also hear of service marks, which is what the SM is that you see here. It's the same thing as a trademark. There's no difference except that an SM represents a service and it replaces the TM with an SM. So if you have a service-based business, you'll see an SM. If it's a business delivering a product or service, and you can actually use TM even still for a service, but sometimes you'll see SM replacing the TM because it's specifically relevant to what that business offers. Now, just like copyrights, you can insert your TM or SM by adding it to the top right-hand corner or the bottom right-hand corner for free. You don't have to pay anyone or register as soon as you start using that mark in commerce, like I did here with the Invention Accelerator logo. So you have a little TM down at the bottom because I haven't registered it. By adding the mark, you put the world on notice, just like with copyright, that it's yours and you can choose to register it later or really at any time. If you do choose to register the mark, which means paying the USPTO to review it and make sure that there are no conflicts with other registered marks out there or any other art for that matter, and you're approved by the USPTO, then this TM or SM changes to this circle R. So really what you're seeing here is something that you can add for free to the name of your product or the name of your business or a slogan or a logo that you create. And then if you see this instead, that means that someone has paid and been approved by the USPTO, and you replace that that mark with the new Circle R mark instead, letting the world know that you own those rights with the USPTO. And again, you can use this right away in all of your marketing material. You don't have to register it first. Just add it to your sell sheet, or if you have a clever name for your product, just add the TM. There's two ways to register. Oh, I'm sorry. First of all, it does last forever. That's what's really interesting about trademarks and service marks. Potentially, they can last forever, but it has to be renewed every 10 years at the USPTO. So if you file a registration, then it's technically good forever as long as you renew it every 10 years and it still was being used between that 5th and 6th year after you originally registered it. If you were still using that and then maybe even took a break, you can still renew it at 10 years and keep it going potentially forever. There are two ways to register. You can either register locally with your Secretary of State where you live, or at the federal level with the USPTO. Now, if you're going to file a trademark for your business or your product, it really doesn't make sense to do it locally if you're planning on doing business nationally or even internationally, right? So if you have a corner store that doesn't really matter on any kind of a national or international level, then maybe just filing it with the Secretary of State would be enough. But in most cases with inventors, if this is important to you, or if you're going to make and sell your product yourself online and you want to register it, then it's better to do it with the USPTO and not on the local level. This is one of the most common questions I get from inventors. Should I register a trademark? I have this really cool name for my product, for example. Well, there are a lot of legal requirements for getting a trademark, and I'm not going to go into all of the details today because I just want to give you a general understanding of what it is and when to use it. But generally speaking, it's very expensive. So for that reason, I don't recommend paying to register it. Not to mention, it's really unlikely that a company is going to pay you, even if they license your product and like your name and want to use it. It's very unlikely that they're going to pay you for it because you haven't really built any intrinsic value in that name. In fact, it's just as easy for them, and free for that matter, to come up with their own name and add it. So why would they need to pay you for it? Because you haven't built any brand recognition. Now, if they really like it, they may choose to use it. It's just not entirely likely that they will pay you for it. But you can definitely use the TM while you're thinking about it. Who knows, maybe in the end a company will want to pay you for it. And so if that is the case, you can always file the registration later. In fact, a good example of this was Scuncy, who I licensed a few of my products to, but the French Twister was my first one. And the reason they became Scuncy was because the woman who invented the Scuncy, the scrunchie, when they licensed the product, they liked that name so much, they decided to name the entire product line after it. So they actually licensed her brand, and her attorney went from that meeting, because they had no idea that it was going to turn into a conversation about the trademark. They went to present and license just the scrunchie. But by the time they walked out the door, they realized that what was being called L&N Sales at the time wanted to buy the brand as well. So the attorney went straight to the patent office and actually filed that registration. So it may make sense, but you can always do it at another time. So that's copyrights and trademarks. Before I jump into patents, please let me know if you have any questions. I know I'm kind of humming right through this right now, but it's going to be a lot more helpful for you when we get into patents if you understand what the differences are. Okay, so copyrights protect your original works of authorship. Trademarks protect names and logos. Patents protect inventions, discoveries, or more specifically, they are the rights granted to you by the federal government that permits you to exclude all others from making, selling, or using that invention for a period of time. So what that simply means is that the invention cannot be commercially made, used, distributed, imported, or sold by others without your consent. Technically, that's a legal monopoly. I'd say it's the last legal monopoly in this country. There are 3 different types of patents that we're going to know about, I should say. There's a utility patent, there's a design patent, and there are plant patents. That's right. The peach was actually a plant patent that was cross-pollinated from 2 different seeds. Now, in the nearly 30 years that I've been doing this, I've actually never had a client with a plant, so I will forego that one and stick with utility and design patents for today. First of all, anyone can apply from anywhere in the world. I had a question the other day from someone who lives in India. Could he file his patent here because it didn't make sense to make it and sell it in his area? And yes, the answer is yes. Anyone from anywhere can file a patent in the United States. Your patent pending the moment that you mail it, if you send it registered mail. So if you don't, so what that means is as soon as it's patent pending, you can start stamping your paperwork, even the product if you're making it, with the term patent pending. If you do not do it when you mail it, if you do not do it registered mail, and I think it needs to be certified also, forgive me if I'm not correct on that, but you'll have to wait until you hear and are notified back from the USPTO if that it's been received, to then be able to start using the term patent pending. So just go ahead and mail it registered, certified mail. It must not have been disclosed, being your invention, your product, your idea, must not have been disclosed publicly more than 12 months prior to filing. Now, this doesn't matter what kind of patent you're choosing to file, what kind of application you're trying to file. It has to have been kept confidential, no less than 12 months prior. So if you have been soliciting, marketing, or promoting it in any way, shape, or form, you've started the clock the date you originally went public with that idea, and that gave you 12 months to file the application. If you don't, it's abandoned, it becomes public domain. Nobody can get a patent on it. And finally, once this is consistent with all patents, you have additional considerations. It's not just filing the application, but you will also have something called office actions, where the patent examiner gets your application, opens it up, reads through it, and then responds to you with either objections or rejections about the application, where there's some negotiation that goes on. So those are called office actions, at which point either the examiner decides to issue the patent or does a final rejection, and it can't be approved. If it's finally rejected, it's done. There's some things that you can do to overcome that, but generally it's not worth it. If it is issued, then following that, you will have a issuance fee, and you will have ongoing maintenance fees at 4.5, 7.5, and 11.5 years. So the USPTO does have an inventor hotline, and in my experience, they're very helpful if you choose to do this yourself. But their job is not to advise you on what's necessary to help you. Their job is only to help you on what's necessary to get you through the process. They're not allowed to give you any kind of legal advice or insight on the ramifications of any choices that you may make in amending the claims or whatever it is that they help you do. They're not giving you any legal advice, so it could be that that advice ultimately narrows your patent down, and if it's too narrow, it may be easy for someone to invent around you. So if you choose to do this yourself and work with the USPTO Inventor hotline, that's fine. I would still really encourage you to at least have a legal eye look at it and tell you what's in your best interest and what the ramifications are of any changes that you do make before submitting that final application. Don't forget that if the patent is the bedrock of your income, just like with the copyright and the trademark, it's worth registering if it's what you're making money from. If the patent is really the core value of your value proposition and how you're going to make a living, this is not something to cut corners on. Make sure you get it right. So let's talk about utility and design patents and how you can go about getting those. So design patents are granted, and you may be wondering, what about provisional? Why isn't she saying, hang in there with me? I'm going to tell you more about that in just a moment as well. Design patents are granted to protect the unique appearance or design of manufactured objects. They are ornamental in nature and cover the overall design of that object. So in other words, it covers what your invention looks like. It does not cover the way that it functions or any of the internal or mechanical structure at all. It only protects that appearance. So if what it looks like is why people will buy it, then a design patent could be for you. I'll give you an example, in fact, of that in just a moment. Design patents really have to pass 3 tests to be approved by the USPTO. They have to pass the novelty test, which is that it's new. In other words, it cannot exist in any form, written, pictures, on the market. I don't care if it's in hieroglyphics on an ancient wall in Egypt. It cannot have existed anywhere at any time. It has to be original, which means if it simulates a well-known or a naturally occurring object or person, it's not original. And it must be ornamental, which is as it is implied by the word design patent, right? You're asking to protect what it looks like. A design patent application must include one claim and as many drawings as possible and an explanation about those drawings to help explain what it looks like for the overall design. A patent claim is indisputably the most important part of any patent specification. So basically, a patent claim defines exactly what it is that you're asking to be protected, and it clearly lays out what the patent does and does not cover. These are good for 17 years from the date that you apply, and the filing fees are $250 for a micro entity and $510 for a small entity when you submit that application to the USPTO. So that's in addition to whatever other fees. If you've hired someone to help you do it, you have to pay that filing fee to the USPTO. I'm assuming most of us here are going to be micro entities and won't qualify as a small. I do because I have a number of patents, but you can find out the rules for all of that and what your status is either from your attorney or on the USPTO website. Attorney fees range, and they're all across the board, but basically the national average that I've seen are, for a design application specifically, are from about $1,500 to $5,000 if you choose to work with an attorney to get your design patent. Don't forget to drop those questions in the chat box here and we will get to them, and of course I'll keep checking back for that as we go as well. So one of the most common questions that I get about design patents is, what percentage of difference does my invention need to be to get away with, to be able to get a new patent? And the answer is, it's not a percentage of difference rule. It has to answer the question, does it prove to be substantially similar in the eyes of an ordinary observer? So in this example, the inventor of the stem for this fork had brought action against these 2 designs and were found to be, on behalf of this inventor, substantially similar, and so they were no longer able to, I guess they got their patent invalidated as a result. So there's no percentage here, it's just answering that question, does it prove to be substantially similar in the eyes of an ordinary observer? In this case, it proved to be substantially similar and their patents were invalidated. This is why you need to have enough drawings to demonstrate every possible view, give it the perspective. Design patents get a really bad rap in the invention community in particular because they hear from attorneys as well that, it's really narrow and it doesn't give you as much protection. But if what it looks like is why people are going to buy it, then a design patent will get the job done for you and can save you a lot of time and money, which we'll talk more about when we get into the strategies here as well. So here's another great example. I'm sure you've got at least one of these at home. I mentioned earlier this scrunchie. Maybe one of these is laying around your house. But Rami Revson invented this back in 1986 with a simple design patent and only 4 drawings. That's all she had. This was the whole patent. Now think about this for a moment. There are billions of these still being sold around the world today. And that was back in 1986. But there's even more to the story than to the power of this patent. She not only created and earned a lot of money by licensing this design patent with L&N Sales, who became Scunsy. And they were originally just a novelty company. They didn't have a bunch of hair accessories. They may have had 1 or 2 at the time, but they were more in like Spencer's Gifts and things like that back then. At the time, they only had about $50 million in sales. Well, Rami licensed this product, and because this product was patented and there were competitors out there like Goody and Conair that were selling similar products, L&N Sales, now Scunci, was able to sue the stores and tell the stores they no longer could sell that product because they owned the patent rights. And instead, as part of that settlement, they were unable to get in the store and sell these products as a novelty company. Well, now that they had this design patent that was already basically being sold and doing well in stores, the stores needed and wanted that product. So all they had to do was move the infringers out of the store and move the actual owners of the intellectual property into the store. And that was the beginning of moving Scunci from a $50 million company to a $500 million company. They got in by suing their own customers. So a design patent can be very effective when what it looks like is why it will sell, or changing the design isn't going to make it work any better, for example. Remember that having a patent permits the inventor to exclude others from making, selling, or using the invention for a period of time. So in this case, she licensed those rights to Scunci, so they had the right to enforce it. They deeply valued the power of the patented innovation and grew the company, and they dominated, by the way, that $500 million dominated the market because at the time the category was still only an $800 million category altogether. So see, a design patent can get the job done. Before I move on here to utility patent applications, any questions? All right, well, I'll just keep my eye open on that screen. Utility patents, which are also called non-provisional patents, are the most common type of patent. These are granted to new machines, chemicals, processes. They can be filed initially as a utility patent application, or they can be filed initially as a provisional patent application, which I will explain more next. The tests for granting a utility application are different from doing design patents. Instead, it must be novel, which is the same as new, but instead of ornamental, it has to be useful, which kind of makes sense, right? Design is ornamental, utility is function. So it has to be useful, and it has to be non-obvious. Utility patents are much harder to get than a design patent because the tests are more stringent. The useful test is the easiest test to pass. If anyone would ever use it, it passes. So, okay, good. We're good to go with that one. But new and non-obvious tests are significantly more difficult, and what you will most likely get challenged on from an examiner and require office actions for you to go back and forth on will be the non-obvious and the prior art. So new means that there can't be anything like it anywhere, just like we talked about. And the non-obvious test is really tough because sometimes you're asking the examiner to basically look at what you've just submitted and said, here's my idea and it's brand new, but they're looking at it in hindsight. Now that they're looking at it through the eyes of hindsight, they're saying, oh, that's obvious. Well, of course it's obvious because you're staring at it. But what it means though is if I were holding my invention, non-obvious means if I were holding my invention behind my back, and like the French twister, for example, and asked an expert on hair fashions, how could you create a French twist? Would they describe what I was holding behind my back? That's technically, if not, then it's not obvious. If so, then it was obvious. Not in foresight, or not in hindsight, it has to be non-obvious in foresight. Now, with all that legal explanation mumbo jumbo kind of out of the way, I think you get the idea. Unlike design patents with just one claim and drawings, the utility application requires substantially more information, which is part of why it's so much more expensive, but also so much more valuable. It's good for 20 years from the date that you apply, and the fees range from $455 for microentity, this is the filing fee, to $830 for a small entity to file. Once approved, the issuance fee is $300 for micro and $600 for small entities. So the utility patent fees cost almost twice as much as the design patents. And again, the attorney fees range from now $5,000 to $15,000. So it's significantly more expensive. And you can see why. There's a lot more work to do here. Now, I know that's a really big difference, but there are also a lot of variables, and any patent attorney is going to be willing to give you at least one free consultation to give you an idea on what that cost would be for your inventions. So let's take a look at an example of a utility application. There's no doubt that a utility patent is better than a design patent overall because of the broad protection. It covers what it does and how it works, and it can take many forms, many shapes. It can be done in many designs, so it gives you just that broader protection. One of my attorneys explained it to me this way. If you put up a fence around your property, right, and you're going to protect it, then you're going to put the fence out on the furthest most limits of your property. You want that fence to be the widest perimeter as possible, and probably have your home in the center. And even if that fence goes out beyond the property where you won't even probably walk or spend time, that's okay. You want it as far away from protecting where you are, where your family is, what you love and want to protect most. You want to keep the wolves as far away as possible. So essentially what a utility patent does is it gives you that broader protection. It keeps people even further away than what a design patent will do, particularly if what you're trying to protect is how it works, not just what it looks like. So for example, clicks here. This is a contour clip. In fact, I have it here. So this one is being sold. You can go into any store and buy this under the Vidal Sassoon and also under the Revlon brand. It has a total of 6 claims, which I didn't list all of the claims here, but it does. It has 6 claims. 2 are independent, and the rest are all dependent on the first 2. The more independent claims, the broader the protection. You can file up to 20 independent claims before getting additional fees incurred from the USPTO. So when you file, if you have more than 20, you're going to pay more as well. But we filed more independent claims and got them turned down, and so we ended up with 2 after doing those office actions with the USPTO, and got this really simple product approved with just the 2, and ultimately it's had to be defended many times and in fact enforced many times in court, and has lived up to that test, thank God, over and over again. I ultimately sold this product. First, I licensed it to Helen of Troy, and they put it under the Vidal Sassoon and their Revlon names. And then a year later, I sold it, which I wish I hadn't, because it's become the #1 product under those brands for hair accessories of their entire history of all time. So that's okay. We learn from our mistakes. Now, obviously, I wanted to flesh out the best final product as possible for my model when I was developing it to ultimately license the patent. But I looked at basically whether I would put teeth here or not. And in the end, it has 3 teeth. You may be able to see here. So it has 3 teeth instead of the 2 on the drawings, which doesn't matter. And I don't have any teeth under the lip here at all. But those were the claims, and that's how we were able to protect it. Now, the fact that it has a little design going from 2 to 3 doesn't matter, because we said 2, or it could be made with 2 or more teeth for inserting in the hair. So that's what kept it as broad as possible, and generally speaking, that's what utility patents do, covering what it does, how it functions, versus design patents and how it looks. Let me show you how you can mitigate some of your risks, though. If you think that you want to get a utility patent filed, an application filed, or even ultimately have a utility patent issued, then you can mitigate your risk by getting a temporary patent pending on a utility application by filing a provisional patent application first, otherwise known as and called a PPA. So remember when I said utility patents can also be called non-provisionals? Well, that actually started when provisional patents were offered by the USPTO, I don't know, 15 years ago or so. A provisional patent application, or a PPA, is a precursor to filing a utility patent application. So they only work in conjunction with utility patents. They do not work with design patents. It allows you to file without most of what is required to include in the utility application. So all of that information that I listed for the requirements for utility, you don't have to do with a provisional. A PPA only requires a cover sheet, a written description of what the general invention aims to do, what it does, and drawings, and these are informal drawings, or it could even be photos, which you can't do with a utility application. Photographs, that is. It gives you 12 months to use the term patent pending while you fine-tune and solicit your invention. So think of it this way. Think of it as a temporary patent pending for a utility patent application. It's filed away by the USPTO and does not even get examined. When they receive it, they put it in a file, shut the drawer, and they do not even look at it again until you submit your utility application and try to claim that earlier filing date. So, and even then it's only, I should also add, even then it's only examined to confirm if they're indeed the same thing. It's not fully examined, it's not judged or anything. They just want to make sure that the utility application that you're now filing is indeed the same invention that you originally filed so that you can claim that earlier filing date. So with a very scaled back version, you only need to pay $75 as a micro entity or $150 as a small entity to file and get a patent pending. Basically, you're buying the term, the label, patent pending for 12 months, which is great because at any time before that 12-month deadline, you can start the examination, you can file, a utility patent application and claim the earlier filing date as long as you do it any time before that deadline. So you might find out after a month, oh, hey, we have a company that's interested, they want to license it, great, I'm going to go ahead and convert it to utility application, or you may want to wait that 12 months out. The only difference is that you'll have to include the reference in the utility application to the original PPA so that it can claim that earlier filing date. Now, assuming that the utility application issues, that one's good for 20 years from the date you filed the utility application, the original application. So for example, if you waited the whole year out on the PPA and then you filed the utility application, then you get 21 years instead of just 20 years of protection. So can you see how having less requirements and spending less to buy an extra year of life and protection could be handy? Let me know in the chat. Now, the flip side of that is that you will have to pay for the PPA in addition to the utility application. So you've got extra fees. So you may decide that you're sure about your invention and you're ready to just move forward and you're going to skip the PPA. But I'd say it's a small price to pay to test your invention out and mitigate your financial exposure, because if it doesn't work out, you can always walk away after spending as little as $75. If you prepared it yourself and filed it, it only costs you $75 if you fail. And I'd say that's a good business decision. I can tell you, if you work with one of, a great trusted service provider, a good attorney, a skeleton patent application will cost about $150, $200 to file yourself, to be prepared, plus your filing fees. And I've seen attorneys draft PPAs as if it were a full-blown utility application and charge thousands of dollars for it as well. It's just kind of across the board. It depends on who you work with and how much work they're going to put into it. So if you're talking to an attorney, you'll definitely want to let them know, or you'll definitely want to ask them what those costs are before you make that final decision. So now let's talk about strategically how to choose the right protection for you. First of all, I want to point out that at the end of the day, whether you choose a design or a utility patent for your protection, it's only valuable if you monetize it. I call it expensive wallpaper. These patents on my wall here, it's very expensive wallpaper unless you monetize it. And as a licensing business, if you don't bring a product to market, the patent just becomes expensive wallpaper. This is why I refer so much to mitigating your risks. You'll hear it in all of my videos. And we do this with a purpose-driven strategy. So let's review the difference between a design and utility patents to determine which you would choose, which patent protection you might choose, and which is better for you and why. First of all, you may choose to file a design patent when what it looks like is why someone will buy it. So if the value is intrinsic in the design, or if designing it that way is the only way that makes it functional, then a design patent will work for you. If you want to have more or additional protection, you could do both, a utility and a design patent. So for example, with Scunci, when I filed a utility application and licensed it to Scunci, and then they came back and asked me if they could file a design patent on the product. With their money, of course, then it came back out of my royalties, but it was important to them to have, especially since they had just gone through all these other lawsuits, to have as broad a protection as possible. Design patents are faster and easier and a lot less expensive to get. You may choose to file a utility application when what it does is why someone will buy it. So if the value is in its function, like how it works, then you'll want a utility application. So like I said, a PPA is a great way to save money and test your product on the market, but they never issue. They go into a drawer and they are either converted to a non-provisional or abandoned. So they have to be converted to a utility application to get examined and then ultimately be issued. It is a great way to save money and test it and then decide to walk away or convert it later. Some companies will not even look at your invention for consideration, though, unless you actually have an issued patent. So please keep that in mind. If you have not done the research, there are some companies that you will find only look at inventions that have an issued patent because they're trying to insulate themselves from frivolous lawsuits or just flat out expensive lawsuits. The automotive and original equipment, OEM, original equipment manufacturers in the automotive industry, for example, you cannot submit a part for a car to make a car run better, for example, without having an issued patent. So in that case, a provisional application may not make sense. You may want to go straight to utility, unless you want to be able to have those conversations with people that you feel a little bit safer and you want to establish that earlier filing date because you're protected from the moment. And I have another video on PPAs that we just did last week. So for more details on PPAs, you can go there as well. But it will establish an earlier filing date and at least give you the illusion of being protected while you're having a conversation with someone and have patent pending, but you'll still have to convert it to utility. So keep in mind who you're going to license to when you're making a business decision between a design patent and a utility patent strategy. If you decide that utility is the right patent for you, then you can choose at that point if you want to file a provisional application first or if you'd like to go straight for a utility application. If a design is better for you, then a provisional is absolutely not a good idea because it doesn't convert to a design patent. It only converts to a utility patent. So you'll want to just file a design patent if ultimately that is what you want to get. So there's your strategies. Now let's just talk a little bit about searching. And I told you to hang in there. We're just about to wrap up and I'll share with you. I'm happy to answer any other questions that you have. But now that you know what they are, you can do your own search, and I'll be doing a video coming up here in the next few weeks on how to do a search. But basically you can go to google.com/patents and you'll see in fact, the images I showed you earlier of the design patent and the utility patent both came off of me searching myself on, Scunci and myself on google.com/patents. And it's just like doing a Google search. Suffice it to say, you can do your own search for free on the website. It's a lot easier than going to the USPTO.com website. Much more complicated. Just go here. It's pulling from the same database anyway. However, you need to know it is not a thorough search. It is not checking necessarily patents from around the world. And understanding how to interpret and read those patents can be very complicated in knowing how to weigh out if something looks close or not. So you'll want to save whatever you find that might be similar and share that with your either patent attorney or patent agent if you decide to use someone to reference when you file with the USPTO, and be prepared to have those conversations. You can download and save the PDFs right from google.com/patents. The good news is you can do a quick search and get an idea of whether or not you have a green light to move forward, and either hire a patent attorney or even hire someone to do a search for you. If you would like a great deal, check out Barry Chobin at Patent 360. He's a former United States Patent and Trademark Office examiner with his own practice now, and he'll do a thorough search for you, ranging from $199 to just $299. And with that, you'll get a copy of all the patents that he references, because he knows and understands what to be actually looking for. So if you're not sure, I would always do a free one first and then hire somebody if I felt like I wasn't quite sure, or I was confused about something that I read. And it also includes foreign patents, and that's a really big advantage, because I don't know about you, I don't know how to read foreign patents at all. And to wrap things up, I'll leave you with this. Getting people to make the switch from what they currently use is so much more than getting a patent. You have to invent solutions that have enough highly meaningful benefits that all add up to being dramatically better than all the competition. And getting a patent is great, but if you get a patent on something that won't sell, it just becomes expensive wallpaper, right? So, if you would like to take my free 1-hour course on how to invent and license, please check the link below. There's also a link below for a free 1-hour consultation. It's normally only 30 minutes, and I upped it. I literally went into the system and upped it to an hour for today, for having watched this video and taken the time to learn from me, especially as I've navigated my way through some of the bumps of the technology, being my first time with this technology. And in addition to getting the added free 30 minutes, because it's a 1-hour consultation, I'm also offering a free comprehensive patent search for using Patent 360. I've done in partnership with Patent 360 for the month of March for every new Invention Accelerator student. So that's a $300 value that includes the report, the issued patents and pending patents that he finds, European issued and pending patents, and most international patents within the last 30 years will all be included in that patent search for you. And that is available to anybody for the month of March who becomes a student with the Invention Accelerator. You can also book your free consultation in the link below to learn more about it or get your questions answered. And I'll do anything that I can to help you. Those calls are valuable. I intend to have you get off with your questions answered for your invention, whether you choose to work with me or not. It is not a sales pitch. It is truly an opportunity for me to serve you. Hopefully help you go from maybe that stuck and confused place, like I mentioned earlier, to having the confidence and the competence to move forward. So with that, if there are no other questions, I will wrap it up. I love you all, and I appreciate you so much. Thank you for bearing with me through some of my technical glitches. I'll continue to do these and get better at them as we go. I wish you all well, and I will hopefully see you on a call.